cause number in front of me. This is show cause hearing. Mr. Hampton, the way we usually do this is we will allow you to make some opening remarks, say what you want to say if you want to, and then we'll ask you some questions. Or if you don't have opening remarks, we'll just start right in. Would you like to have something to say? Okay.
I was a little perplexed about it, but I think I figured out why I'm here. And so I think if I explain the sequence of events, that might answer a lot of questions right up front. So when the Kerry Max Cook decision came down, the first thing I did either that day or the next day was to work up an order of dismissal. And I emailed that to the Smith County District Judge. He responded in a way that I didn't really actually understand, which caused me to start thinking, oh, he thinks that a mandate has to issue. And I'm thinking, well, he's wrong about that because mandates only issue in direct appeals. So I looked at the rule. It was unclear to me, so I called, which I never do, but I called your executive director and said, you know, tell me about mandates. And she said, yes, we issue mandates in 1107 post-conviction cases. I said, I didn't know that. And I think she's the one who said, I thought you should know that because you filed a motion to expedite a mandate one time. And I was like, I don't remember that. I'll go find it because that's what I'm going to do. So then I filed the motion to expedite the mandate for the reasons that were stated in there. So I filed that, and the two lawyers I work with from New York, they let me know, hey, we've already talked to the elected DA. He's good with the dismissal. And I put that in my email to the judge. So it's over. The case is done. Let's get the dismissal. So the next thing, the next two pleadings I see is the assistant DA, he filing his opposition to the expedited motion to expedite the mandate, and then a motion for rehearing is filed. And the New York lawyers called me again and said, can they do this? And I laughed and said, no, they can't. They cannot do that. I know the rule very well. You cannot file a motion for rehearing after in 1107 cases. I filed plenty of suggestions to the court to act on its own motion, but there's a specific rule. I'll double check that. So I checked the rule, and to my surprise, of course, I've only read it for myself, not for the state. I've never experienced this. And the rule says if we lose on 1107, it's over. If they lose, it's not over. They can file a motion for rehearing. So it was at that rather late date that I realized that they actually can do this. So that's it. That's what happened.
Well,
and my choice of words, yeah, I guess I should address that as well. Okay, the first part of that sentence, and I hope I identified the correct sentence. I think I did, because there's nothing else in Mr. West's motion, I don't think. But the first part is indisputable. There's no factual dispute about that. The judge, you saw the email. From the elected district attorney himself, I've got no opposition to your to the order of dismissal. He says he doesn't think it's necessary, but no opposition. I stated that. I'm right. That's the truth. The second part of that, I think you're reading the second part of that in a way that was not intended. And I've thought of this. I guess the phrase by extension, if I'd worded it accordingly or presumably or logically speaking, because that really was my mindset. Look, the case is done. It's over. you don't oppose the dismissal. Let's get this back in front of the district judge.
But they didn't oppose the dismissal of the writ, right?
I don't understand.
Well, in that email exchange, first
Oh,
of all, yeah, your order of dismissal has an A after the cause number, as if that were a writ. And then in the email, it says, we don't oppose, I'm not sure this is necessary. The proposed order dismisses the writ.
Right. I didn't catch that myself until I reread my own proposed order. It looks like the writ. I asked him to
Right.
dismiss the writ, and of course, that's not what
And
I'm
that's
doing.
what they were unopposed to.
No, he's reading that correctly. It's just the style is wrong. That's
So you're
all.
saying Judge Keel is reading it incorrectly?
No, she's read literally ex parte with the cause number of the writ. The writ's not dismissed, the writ was granted. He's got no authority over the writ.
But if she read it correctly, but you're saying that the DA read it correctly, I mean, if he's thinking it's the writ, then I'm confused
No,
here.
Well, he doesn't. I haven't talked to him about it, but I don't think he thought
Let me tell you
that
why-
deeply through that.
Let me tell you why I think that he was talking about the writ and you were talking about the prosecution. Because he says, we don't oppose, I'm not sure this is necessary. The proposed order dismisses the writ, which you have already prevailed on. It also identifies the writ as a criminal prosecution, which it isn't. I don't think there's anything to
Exactly.
dismiss. So
I think you're right, actually. I've been thinking this whole time, there's only one thing that can be dismissed, and that is the other cause number, the non-writ.
Right, you
There
wouldn't
is a
want the
pending,
writ
there's an
dismissed.
indictment sitting in Smith County with Kerry Max Cook's name on it. I'm not actually looking for the writ to be dismissed. I know the style. I got it wrong. You're probably right. Maybe I didn't give him enough credit that he looks at that and goes, Hampton, you're moving to dismiss a writ where relief was granted. What are you doing? Yeah, I've got no opposition to that. Knock yourself out. I didn't read it that way.
Do you understand why it is this appears misleading?
I'm getting closer.
I mean, surely you can see that. I mean, you can see how this seems misleading. That the communications you've had to this court is misleading.
I'm struggling, actually. I thought it was the sentence that I identified. I didn't actually think.
I mean, with that sentence and the support you have for the conclusion that you drew. I mean, you didn't check with people to get to this point, and you've said multiple times, I'm wrong. Why isn't the logical conclusion that, oh my God, now I can see why this is misleading?
I'm sorry, I'm just struggling with it. It's misleading. I'm thinking in the ethical sense, that I'm intentionally, see, this is what I thought. I'll tell you what I thought you thought. That I knew there was a motion for rehearing, and I'm trying to preclude their ability to do it.
Right.
But, okay, well, you
Well, that's the communication you had with New York.
that's
When
true.
they asked you
If
can
they
we
could do it,
this,
and I said
and
no.
you said no.
That's right.
And you've been practicing how long, and you're not keeping up with the rules?
Well, I'm sorry. That rule is ingrained in my head because it's so explicit to the defense. I mean, I've looked at that rule many times, but never through the eyes of, could the state do it? It's just a prohibition on us. And
But then you're representing to the court that the state's not opposed to that. And, and when they were planning to file a rehearing.
I didn't represent that as a fact. I told you that was my rationale. The rationale was surely you can't be opposed. That by logical extension, like I said, maybe if I'd used the word presumably, that would have conveyed a different sense. But I didn't spend a lot of time wordsmithing this. This wasn't some strategy on my part. I wanted to move the thing to Smith County as fast as possible. It was that simple. And I thought it was over until, until another motion for rehearing was filed. I was surprised that they even filed it. I'll tell you, our workings with Mr. Putman, the elected DA of Smith County, who I've never met before, our conference calls were quite cordial. It was seamless. We planned things. It was great. And all the vibes were, hey, the decision's been made. We're done. Austin's over. Let's get back. I'm ready to go. You're ready to go. That's what I was thinking. I'm sorry if you were misled.
What you think was gonna be dismissed?
The proceeding, there is a live indictment sitting in
Yes.
Smith County, and it needs to be dismissed in part for satisfaction for the Civil Practice and Remedies Code that govern the wrongful incarceration provisions.
So when the DA says in his email, in writing, that you're not seeking a criminal prosecution's dismissal,
We were talking past each other. I was assuming,
and yet you tell the court that he's unopposed.
that is how I read his response. I was not giving him enough credit. He was actually being quite technical and correct, and I was thinking, you don't understand.
Well, he's
I'm not
using
looking.
plain English, he's not using technical language.
No, his analysis is, and that's why he's perplexed as to why would I move to dismiss a writ wherein relief has been granted. That makes no sense. So he's actually, that's a smart lawyer. I didn't give him enough credit. And it was only later that I went, oh, that's what he's talking about. I got the style wrong. I put ex parte, and then I put the cause number with the dash A. And then I corrected it, removed the dash A, and substituted State of Texas versus Kerry Max Cook. That's all there was to that.
And in the body of the proposed order, it says dismiss the prosecution.
Right. That's right. And, which perplexed him because, to his credit, he was reading it, what proceeding? And I'm thinking he's got it wrong until I realize, oh, it's the style. I copied the style.
If you had a good working relationship with him, why not just shoot him an email and say, are you opposed to the mandate being expedited?
Yeah.
Just simple, straightforward
Sure.
language.
I agree with that. The dealings were primarily with the other attorneys. I was on a couple of conference calls with him. Remember they discovered this box in November, and then there was...
But we didn't know anything about that.
We didn't-
Nobody ever told the court that there was this mystery box in Smith County.
Right.
That everybody was discussing about testing.
And all those communications, because they have expertise in DNA, was the lawyers in New York and Mr. Putman, not me.
But if you're making a representation to the court that, or insinuating a representation to the court that the DA is not opposed to your motion, isn't it your obligation to actually confer with them?
I did. They told me that. Talked to them almost every day on the phone.
But they told you they didn't oppose the dismissal of the writ.
No. He said, I'm reading this purely as the proceeding. It makes no sense for me to seek to dismiss a writ where relief has been granted. So I'm never thinking that. I'm thinking only of the proceeding. So when I talked to the guys from New York, and they said, hey, we've talked to the elected DA and he's good with it. I didn't see that email. If you notice, I'm not on it. I'm pretty sure. Please check. But that's communications between Mr. Putman and Mr. Garber and Ms. Friedman. And that's what was conveyed to me. None of these people are drawing nuanced legal distinctions here. I'm thinking it's over. How fast can we get it done? Good news, he's not opposed to the motion that you sent to the judge for the dismissal of the criminal proceedings.
But
That's it.
there's this other element of that sentence that talks about, so it says the dismissal is unopposed because there's no reason for opposition.
Yeah.
And then
Yeah.
it says, and the speed of dismissal is by extension also unopposed. Those
Right.
are two times
Right?
that you're suggesting a lack of opposition. But, so, wait for me here.
Okay.
One of those is talking about the lack of opposition to the dismissal, I take it from what you said today, of the indictment that was still on file
Yes.
back in the county.
Right.
Why are you referencing the speed of dismissal
Expedite.
about, in the context, we've got here an motion to expedite the mandate. That has to do with the speed of things happening. So
Yeah.
you can see how that suggests, go ahead and rule on this quick, because they're not opposed to this.
Right.
That's what it looks like.
I do, and to return, it's crystallizing in my mind. I think, I'm sorry I didn't separate that as a separate sentence or used another word. That was my reasoning, my inference, and I can see that you can read that sentence and say, Hampton's not inferring anything, he is affirmatively representing as a fact that they are unopposed to the motion to expedite the mandate, which is obviously untrue. So if you read it that way, yes, I can see, if that's the source, I totally get it, and I'm just telling you that was not the intent. My intent was, they're unopposed, that's a fact. They can't be, they must be in agreement with the motion to expedite. And I made that inference, if you want to call it that. Wasn't expressed well enough, but there literally is, I think I've said this, I think in my letter at some point, why would you agree? I'm in Smith County and I'm ready to dismiss this indictment. I agree. I'm unopposed. Let's dismiss the indictment. Okay, like next year, you read my motion. You know this guy is back in the hospital. He's not doing well. He spent 40 years with this case. And my short dealings with Mr. Putman, I think 2 conference calls, but like I said, we made beautiful music, you know? And then I'm getting the calls from New York. We talked to him, it's all good. So I'm like, let's move. Let's get this thing back. Let's end it.
Still with this concept of the state can't have rehearing, so.
I know. I just didn't think that. I was shocked at the rule is so one-sided. I've never seen it, actually, but of course I don't get relief granted very often either in post-conviction proceedings, but I've actually never seen the state, it's got to be unusual for the state to move for a rehearing after a writ, but I don't know, maybe they do it all the time, but I don't experience that. And I didn't think they could. I thought they got their style wrong and said suggestion until the people from New York called me up and said, can they do that? I said, well, I'll double check. And
So
then,
I guess you would not be adverse to suggesting to TDCAA that they do some training on rules.
yes, okay. Well, and before I make a decision like that, I should reread the rule. But I actually had pretty high level of confidence that they were wrong. But I double checked and went, uh-oh, they can do this.
So, but that strikes me as still not the point. And maybe I'm just, not seeing things the same as my colleagues, I don't know. But in all of this, I think you just recognized, pursuant to my last question, how what you wrote in your request to expedite the mandate could have been misunderstood by us.
Yes.
As an indication that you had confirmed that the DA didn't oppose the motion to expedite the mandate.
That's right.
And what I have yet to hear, I think, is an apology to this court and some indication that you are going to work a lot harder to make sure you don't do that to us again. And that maybe you would share with other people the fact that this is no thing that you want to go through when you make an error like that. And that's what I'm looking for, and
Sure.
I'm still waiting to hear. If it's there, then you should share it.
Okay.
If it's not, well then just keep saying what you're saying.
All right. I apologize for the wording of that sentence. I do. I apologize. I regret that sentence. I wish I'd broken it up. I wish I had used another modifier. Didn't. In hindsight, that's what I should have done. So I'm sorry.
When we present to the legislature, I am often hounded on because some people over in that fancy building think there aren't any decent defense attorneys in the entire state of Texas. And we defend the defense bar at all costs. So it's not just an apology for poor choice of words, but it should be an apology for not knowing the rules. I mean, this is a big case. This is a big deal. It's not some little misdemeanor. And that's another thing that you should apologize, because you, right now, are a representative of the defense bar.
Well, like I said, I wish I had reworded it. A lot of this stuff was highly unusual and new to me. First time I ever saw a motion for rehearing after post-conviction relief being granted. I was surprised, actually, that it was, and not prepared, and wish I'd been better prepared. Wish I'd foreseen this.
Judges, any other questions? Unless you have anything further to say, we're going to stand in recess for 10 minutes.
All right, thank you, Judge.
All right.
from respondent, and considering the record in the case, the court has determined that respondent Keith Hampton has failed to show good cause for in the matter of candor to the court. Therefore, we find respondent to be in contempt of this court. We will assess a fine of $500. An order will issue later today. And unless you have anything further to say, the proceedings are adjourned.
All rise.